Welcome to our webinar, Estate Planning with Trust and Will, the leading online estate planning platform in the U.S. Slide change. Hello, I'm Chris Raffinham, Manager of Investments for Patelco Financial Solutions. Welcome to the Estate Planning with Trust and Will, the leading online estate planning platform in the United States. Our speaker today will be Dewey, and more about him in a few moments. Slide change. First things first, I want to show this important disclosure of what we sometimes call the not may. In short, investment products are not FDIC or NCUA insured. They are not guaranteed by the credit union and may lose value. Slide change. Now, let's go over a few housekeeping items. All participants have been muted in listen-only mode. There will be a lot of information today. At some point, it may feel overwhelming, but relax. That's why the webinar is being recorded, and the replay will be sent to you in 1 to 2 days and will also be posted on our website. Our main speaker will present for about 25 minutes. You are encouraged to type in your questions regarding today's webinar topic in the Q&A section as you think of them and at any time during the presentation. In addition to the Q&A session after the presentation, there will be 2 experienced team members from Trust and Will who will respond to many of your questions live. This is a well-attended webinar, and we apologize ahead of time that we won't be able to get to everyone's questions. However, you will have the opportunity to contact Trust and Will directly after the webinar. Please use the chat for general comments. And remember, it's important to be nice. Also, let me emphasize, at the end of today's webinar, we will be announcing a special limited time discount on your estate planning package. So stay tuned at the end of the presentation. Slide change. Our speaker, Dewey, is a strategic partnership manager at Trust and Will, the largest digital estate planning platform in the United States. O'Neill focuses specifically on credit union space, supporting partnerships with 65 credit unions across the country and providing estate planning tools and education to their 25 million members. On the personal side, O'Neill lives in New York City, where he loves exploring new restaurants and playing tennis on the West Side Highway. I want to turn it over to O'Neill to start the presentation.
All right. Thank you so much, Chris, and thank you everyone for joining today. Again, my name is O'Neill. I know not your typical first name here, but I manage our credit union strategic partnerships and am really excited to share more about Estate Planning 101 so that you can leave here feeling more informed and educated and ready to take some next steps as it relates to your own estate planning. As Chris mentioned previously, I'm joined by 2 of my member support specialists at Trust and Will, Jason Young and Jay. So they are available to help answer any questions as you have them. If you look, I don't know if it's up or down on your screen, but there's a Q&A button. So feel free to open up that Q&A and ask your questions as we go through this presentation, so that you don't forget those questions and you get them answered quickly as we move throughout the presentation. So today we'll be discussing the basics of estate planning. We will start by defining why an estate plan matters and what an estate plan is and does. Then we'll cover some of the key documents in an estate plan and how to decide which documents are best for you. And finally, we'll conclude with who needs an estate plan, some of the most common reasons it might be time to create or update your plan, and how you might get started doing so. Once again, if you have questions along the way, please feel free to open up that Q&A and drop them in there, and Jason and Jay from my team will answer them as they move, as we go through the presentation. So to set the stage for the gravity of this topic, it's important to know that estate planning is the largest personal transaction of your life. That said, unfortunately, it's It's one that most people are sort of unprepared for, unfortunately. And so, without a plan, most people wind up leaving their assets and legacies subject to probate, which means the government makes all decisions on your behalf. Nearly 2/3 of American adults procrastinate on estate planning until it's too late. And the three primary reasons for that are a general lack of education, so not necessarily understanding the risks associated of not having a plan, which we're hoping to tackle today. The cost, typically, and going to an estate planning attorney, you can expect to pay thousands of dollars to draft, estate planning documents, and so that can sometimes feel inaccessible or easy to procrastinate on itself. And then general inaccessibility, so not necessarily knowing who to go to get this right for you. And so Patelco has partnered with Trust and Will to help you through these hurdles with more modern and affordable solution. But we're going to first focus on really the reason why you're here today, which is, what is estate planning? Estate planning is planning today for what happens to tomorrow. At its most basic level, an estate plan lets you make decisions today about what should happen if you are unable to make decisions in the future. This set of instructions specifies what you want to happen to your assets, your belongings, and your personal physical body. So, why should someone care about estate planning? What should motivate someone to create their estate plan? There really are a number of reasons to care. First and foremost, instant peace of mind. You will feel confident knowing that you've taken the necessary steps to protect yourself and your loved ones. You'll also be able to name legal guardians to take care of your minor children and your pets if you have them. Another reason estate planning is so important is that it can help you prepare for potential incapacity during your lifetime. Studies show that the majority of Americans will be impacted by incapacity, whether it's their own or a loved one, during their lifetime. And because this happens during life, it sometimes matters most to people. These are inherently personal decisions, so there's no easy way to have a default rule that matches your desires. Uh, and there's no certainty that anyone else would make the same decisions you would make for yourself. So when it comes to estate planning, the primary motivations can be asset distribution and business succession planning. So asset distribution is the ability to control where your assets will go after your death. You can choose to have assets benefit family and loved ones, to support charities, organizations, and causes that are important to you, and to maximize or minimize taxes to maximize the benefit to your beneficiaries. So many people equate estate planning with asset distribution, and it certainly plays a large part, but asset distribution is not the end-all be-all of estate planning. There's succession planning, end-of-life planning, incapacity planning, all of which relates to healthcare documents, which we'll also cover in this webinar. So we've gotten the why down, but what is an estate plan? An estate plan is a set of documents containing instructions for what should happen if you cannot speak for yourself, whether you're incapacitated or have died. An estate plan is typically multiple documents, not just one, and the documents in a plan will vary person to person, but should be tailored to meet your specific needs. Each type of document is designed to do one thing. Your plan might focus on just one or two of these things, in which case you'd only have one or two documents, or your plan might be more comprehensive with a full suite of documents. Most typical documents are wills, trusts, and healthcare documents. So we're going to dive into each one of those individually. Your last will and testament is a legal document that controls most assets when you die. It goes into effect after your death. So what is its purpose? A will handles fundamental needs for everyone. So therefore, if you are at least 18 years old, a will can benefit you. And there are three primary functions of a will. First, to determine who will receive your assets after you die. Then to nominate guardians for your children and pets. And then finally, to specify your final arrangements. For example, do you want a traditional funeral or a memorial? Do you want to be buried or cremated? So what's the next logical question most people have? What happens if you die without a will? The functions of a will are essential. These matter. So, who will get your things and how to distribute those assets, they have to be addressed. even if you don't have a will. So what happens if you don't have one is that state laws fill in gaps and make decisions on your behalf. So this is one of the most common misunderstandings when it comes to wills. Many people assume that the default state laws will give the same result as what you would have wanted yourself, but that really is not always the case. And I'm going to give you a quick example. So let's say you're married with 2 kids. State laws may provide that your assets are divided 1/3 to each family member. You may not want your kids to get 1/3 of all of your assets right when you die, and your spouse may not be able to maintain the house or standard of living with only 1/3 of those assets. Depending on your state's law, this is what could happen if you die intestate. However, with a legally binding will in place, the court will likely honor your wishes as stated. So let's focus a bit more on how a will works after death. Wills go through probate, which is a judicial process to determine the validity of a will and appoint an executor. If you do not have a will, the court will appoint an administrator to perform the same functions as an executor, usually a relative. But if you have no will, it may not be the person of your choice. The executor, once appointed, is the manager of the probate process, and their job is to collect assets, pay debts, expenses, taxes associated with the estate, and to distribute assets to beneficiaries. But probate is often undesirable because, first off, it's slow. It can take 12 to 18 months in California, and that was before COVID. In some courts, it takes more than 2 years now. Second, it's difficult and stressful. The process begins immediately after death during a period of grieving for a loss. And because of this, it can bring out resentment and can lead to disputes within families. And third, it's expensive. In some states, a $1 million estate can cost over $50,000 in statutory fees for probate, in California specifically. So probate avoidance is a huge motivator for some, and it is one of the primary reasons that many look to set up a trust. So a trust is a legal agreement between 3 parties. There's the settlor, the trustor, or grantor, who creates trust and puts the property into it. There is the trustee, who holds and manages the assets in the trust, and there is a beneficiary, who the trust is in favor of. So basically, the settlor creates a trust and gives assets to the trustee to hold for the beneficiary. There are 5 primary purposes of a trust. First, to avoid probate. This is key for many people. A trust is an easy way to avoid all those negative consequences of probate we discussed previously. But a trust is not only about probate avoidance. You can also manage and distribute assets with a little more control over when and how those assets are distributed. So you can create contingencies for what you can add to your trust. A trust also applies both during your life as well as after death. So this means a trust can be useful in planning for incapacity and can ensure there's a seamless transition of control. Fourth, to provide for your family. This is a really big motivator for many people with younger children and blended families. Trusts give more control over assets that will eventually benefit your younger children and can give more control over providing for your spouse during his or her lifetime, but then ensuring that those assets then pass on to your children after your spouse's death. And a fifth reason is to minimize taxes. So what is the role of the trustee? A trustee is like the CEO of a trust. You're bound by law in terms of the trust, but it is still a critical role in executing the duties. And a trustee can work with other professionals and advisors. And when you're choosing a trustee, you want to select someone that can carry out those abilities and duties. So some popular choices are a spouse, your child or children, relatives, close friends. And there are 4 buckets when considering types of trusts. You have revocable living trusts, which are the most commonly used type of trust. When people think of a trust, they're typically thinking of a revocable living trust. And these are created while you're living. They can be changed or revoked, and the assets within will all avoid probate. Second would be a testamentary trust. These are a little bit less commonly used and are created initially under a will. but then the testamentary trust takes over and is effective upon death. These can be easier to create, but typically do require probate themselves. And then depending on the complexity of your state, there are also other types of trusts, including trust used for tax planning, which some examples are credit sheltered trusts, Q-tip marital trusts, irrevocable life insurance trusts. And there are also trusts used for other special purposes. For example, asset protection trusts, special needs trusts, and Medicaid planning trusts. So trusts and wills have a lot of similarities and differences. Each do things that the other does not. The similarities lie in the fact that both documents dispose of assets. Trusts, and some of the differences are that trusts avoid probate, whereas wills go through probate. Trusts give greater control over when and how assets are distributed. Wills can be easier to set up. Trusts can take a little bit more work. Trusts apply during a lifetime. Wills nominate guardians and specify final arrangements. So trusts are usually actually paired with a will as a set. So when should you consider a trust? One reason is if you have younger children. So rather than having all assets go to your kids immediately or when they turn 18, a trust lets you set triggers for asset distributions. Some trigger examples could be when a child hits a certain age or reaches some sort of life event. Maybe they graduate from college or they get married or hit a certain age. And this helps to stretch out distributions of assets rather than giving them all to someone at once, which could be spent faster. Another reason to consider a trust is if you have complex family dynamics. So blended families, second or third marriages, trusts can let you benefit your spouse for their lifetime and then ensure your assets go to your kids, not to a second marriage or stepchild. And another reason is privacy. Wills become public through probate, but trusts stay private. And a final reason is if you have a higher level of assets, trusts avoid probate, which in California, I believe, kicks in with estates of over 160,000 in assets. And trusts can help you minimize estate and income taxes as well. So the federal estate tax kicks in around $13 million today, but this could be lowered based on the administration in office at any point in time. So something to keep in mind. Also, trusts provide the opportunity for more advanced planning and help you stretch out retirement distributions. So if you have retirement savings that you plan to leave to your beneficiaries, a trust may provide a tax advantage way to distribute those retirement savings over time. So we've covered wills and trusts, but let's talk about the third of the common estate planning documents, which are healthcare documents, which typically are sorted out into three different types. There are your power of attorney documents, healthcare directives, and then HIPAA authorization. These three documents cover what happens when you are incapacitated, while a will or a trust covers what happens to your property when you die. This part of your plan covers your wishes for your finances and care while you are still alive. Your power of attorney designates someone to make non-medical decisions for you. So those can be financial decisions, business decisions, any handling of day-to-day transactions, bills, things like that. Your healthcare directive or living will, as it's also known, specifies your medical preferences in advance and designates someone to make other medical decisions for you when you are not able to voice them yourself. And then your HIPAA authorization ensures designated agents and representatives can speak with your medical providers. They make decisions, can consider costs of treatment, things like that. And it also ensures all stakeholders in your care have access to private health information and can communicate with your care providers about your medical history and decisions being made. And so, this is a piece that's frequently overlooked, but certainly important. So, who needs an estate plan? All adults, at the end of the day, need a plan. And common reasons to create one or triggers to do so are marriage, so getting married or divorced, having children or grandchildren or pets, accumulating assets, any medical concerns of your own, and then also just dealing with a death of a loved one that has impacted you, whether it was close or more of a distant relationship, but it reminds you that you are mortal and anything can happen. And then a final reason would be, approaching retirement and wanting to ensure that your legacy is in place. So your plan should also evolve as your life does, and you'll want to make sure your wishes are properly reflected as your life changes. And so you'll want to change or readdress your estate plan when to do things like update beneficiaries, changing guardians as your kids get older. They may need a different guardian, and generally speaking, you'll likely have different preferences for your plan as you age. Some of the more common triggers to update a plan include births, deaths, changes in marital status, retirement, and in the passage of time. Really, every 3 to 5 years, it's worth revisiting. And as children become adults, they'll need their own plan. So while your child is under 18, you have parental rights. However, once your child turns 18, they'll need to have legal documents to let you act on their behalf. So once you've chosen your plan, you'll only need a few things to get started. I promise it really is not as intimidating as you might think. You'll need some basic information like you and your spouse and your children, full legal names and birthdays. You'll need an idea of who you want to act as guardian for your children and who you might want to appoint as your executor or trustee. And you'll also want to know how your assets should be distributed. So, what percentages of those assets should go to who? And you can include specific assets like jewelry, your car, cryptocurrencies if you have them, or state that you simply want a portion of your estate to go to specific individuals. So, just, on aggregate, that works as well. And then lastly, you'll need the names of financial institutions where you hold accounts, as well as the addresses to any real estate you may own, and if it is applicable, any names of businesses you own. But that's it. What you will not need are social security numbers. You will not need bank account numbers or online passwords or real estate titles or any relevant business ownership paperwork. So, like I said, it's really not as complicated or scary as most people assume. And if you're, not necessarily ready to get started, but perhaps you want a little bit more information on estate planning or to learn a little bit more on the intricacies, you can always go to our website, trustandwill.com. We've got hundreds and hundreds of estate planning tangential articles on end of life planning to help you better understand what happens to things in different circumstances. You'll also have representatives from my team. Our member support team is available to help answer questions as as they come up. So on that note, I definitely want to share a little bit more about how we can make estate planning more easy for you to accomplish and finally check off your to-do list with our modern technology. So, Trust and Will, we are the largest and highest rated digital estate planning platform in the country. You can think of us sort of like a TurboTax for estate planning. You answer, a few questions as you go through the process, and based on the questions or the answers you give, it'll ask follow-up questions, and before you even realize it, you'll have completed your estate plan. Typically takes 30 minutes to an hour to create your plan. So you're saving tons of time and energy. We've partnered with over 100 financial institutions across the country to support their members, their customers, even their employees with estate planning, our estate planning tools, which save on average over 70% versus what you would spend working with a local attorney. So our mission is really to make estate planning affordable, accessible, and just easy to finally check off your list, because everyone on this call today probably has this lingering on their to-do list. So we're here to make it easy. In terms of our pricing today, because you're members of Patelco Credit Union, you get a best in market discount, 25% discount off of our retail prices. So online, if you came to our website, you'd see it's $199 for our will-based package, which includes a last will and testament, living will, HIPAA authorization, and power of attorney documents, all state-specific documents designed by our team of attorneys, but really customized by you to fit your specific needs. And then we have a trust-based package that starts at $499, but again, you'll get that 25% discount off of that. And that includes everything in the will plan as well as a revocable living trust. So this can be a better fit if you have a slightly higher level of assets, you maybe own a home or have some more complications related to your specific estate. And in terms of how this process works is if you still aren't quite sure if a will or trust could be a better fit for you, we do have a quiz on our website that can help guide you to a document that could be a better fit. And from there, it's a really simple and intuitive process. Again, you're asked one question at a time as you move through, and on every page, we'll flip back here, you have a question mark that pulls up additional context related to the question being asked, as well as this chat bubble down here, which pulls up a live chat with our member support team. I think this is really key for you as you go through this process. You can plow through this process in less than 30 minutes without talking to anyone. But if you do have questions, our member support team is available to help you. So 6 days a week, you can chat in with them via chat. You can email back and forth with them, or even pick up the phone and call them. They're not going to offer you legal advice themselves. However, they will be able to um, help guide you and provide education and really help answer your question without saying this is what you should do in your specific instance. They would say more generally, this is something that you could do uh, to uh, to help answer that question and provide additional resources. So finally, to move forward and to accomplish your estate plan, all you need to do is go to the Patelco Credit Union website and search for estate planning and follow the links there to click over to Trust and Will. That 25% discount will be automatically applied, and our member support team standing by to help answer any questions. So I sort of moved a little quickly through the end there, but I wanted to open it up to additional questions that anyone attending may have. We are really excited to help you finally check this off your to-do list, finally accomplish estate planning. You'll feel that peace of mind knowing that your family your legacy is secured, your family is protected. Again, this is the largest financial transaction of your life, and so something to ensure that you're prepared for.
Thank you, O'Neill. Just as a reminder, the presentation is being recorded and you will receive a copy by the end of this week. So it'll also be available on our Patelco website as well. So thanks, O'Neill. Let's go to some questions here. Before we move to the next slide, let's go back to the previous slide. So first question, O'Neill, can the lawyer that prepares or updates your will/trust service as an executor or a trustee or both?
So we have I didn't touch on it. So in addition to our member support resources, we also have an attorney offering as well. So for a flat fee, it's actually $300. I saw there's a typo in the presentation. I'm sorry about that, but it's a $300 flat fee. So you're not paying any hourly rates with an attorney or anything like that. But you can schedule time with a licensed local attorney to provide legal advice for you. And so that is provided through Trust and Will. If you would sleep better at night knowing that your documents were reviewed by an attorney and that you've got those specific questions answered, you can opt in for that through our website.
Great. Here's another one, O'Neill. What paperwork is required to allow your primary care physician to act as your health proxy?
I'm gonna pull in Jason and Jay to help address some of these questions from our member support team. So I don't know if you'd like to hop on, Jason.
Sure. So all of our estate plans come with what's called a living will, and that living will is where you can designate people to make healthcare decisions for you and say what those healthcare decisions are. So that's all you would need to give to your physician, so that they have in mind, your end of life choices. Well, your life choices while your end of life choices while you're still living. I'm sorry.
Thanks, Jason. Appreciate it. Let's review some of the questions in the Q&A that were already answered so everyone can hear them. So I'm going to read a couple here just for everyone to hear. This is the one that has been coming across often. Does a will made in another state, is it still valid in California? The answer is yes. If you created a will in another state and you move, your will is still valid. And here's another question as well. If you have a trust, do you also need a will? So with will and trust, all the trusts also come with a will automatically. And there's quite a few questions coming through as well right now towards the end that we're answering live in the Q&A section. So let me go through a couple more here for some common ones that are coming through. So this one specifically children as the beneficiaries in our accounts. Beneficiaries on financial accounts are not subject to the probate process. There is one thing I want to make clear when we talk about setting up a trust. I want to reiterate the importance of funding the trust and changing the titles of the financial institution accounts and the real estate as well. So that's very important. Once you set up the trust, you have to change the titles of those accounts, financial accounts with your credit union, your bank, and also real estate as well. All right, let's see if there's anything else in here. And Jason, if there's anything in the Q&A that you want to share here that you're answering live to that is a common one coming up, feel free to unmute yourself as well, and we can get those for everyone to hear as well.
Sure. A common one that's been coming through is beneficiaries on something such as a life insurance policy. Those are not subject to probate.
Yes. So thanks for that one as well. And anything else from our panelists that's coming through that you're seeing is a constant question. Just again, we have the link for trust and will that was just put in the chat. And we also have again, want to reiterate, the presentation is recorded and you will receive a copy of it through a link by the end of the week. So if you registered for this webinar, whether you attended or not, you will get that email with a copy of the link and the recording. All right, let me finish up. I know there's quite a few questions coming through still, and thanks again to our panelists at Trust and Will to answering them live in the Q&A section. Next slide, O'Neill. So what do we do here at Patelco Financial Solutions? We have 10 financial advisors available to help you make investment decisions. They can help you with tax advantage income, retirement planning and retirement income, qualified plan rollovers like 401ks, 403bs, and IRA rollovers, financial planning, life insurance, long-term care, and wealth transfer. Our financial advisors are available to meet with you in person, over the phone, and virtually via Zoom. And rest assured, our financial advisors have an encrypted version of Zoom for added online protection. We'll drop a link in the chat to help you locate a financial advisor assigned to your local branch to set up an appointment. Or please contact me directly either by phone or email. And if you do email me, please include the branch that is most convenient for you, and we'll get you to a financial advisor assigned to your area and to your branch. So again, if you do contact me directly, which is preferred via email, let me know what branch is the most Patelco is most convenient to you. Next slide. So this is what you all have been waiting for. I wanted to let you, next slide. I want to let you know for limited time, you'll be able to get 30% off the estate plan of your choice with Trust and Will. And that's for attendees of this webinar starting today, March 27th and then open up to our general membership on April 1st. But just a reminder again, it's a limited time. Get 30% off your estate plan of your choice with Trust and Will starting today, March 27th. And it does sunset on April 30th. So there is a link there to get started, www.trustandwill.com/Patelco30 to get started. All right, next slide, please. And lastly, on behalf of O'Neill, myself, and the entire Patelco team, we thank you for attending today's webinar. And remember, wherever you are in your financial journey, Patelco is here for you. Thank you very much and have a great day.